All right, let's dive right into a truly classic, dramatic legal dispute set in 1950s Malaysia. In today's explainer, we are unpacking a foundational case that really tests the boundaries of loyalty, fairness, and the true cost of doing business. We're looking at the landmark dispute of Sohrabji versus Oriental Security Assurance. So, if you've ever found yourself wondering exactly how the law balances cold corporate decisions with decades of individual dedication, well, this is exactly what we're going to explore today.
But before we get into the real legal mechanics of it all, I want you to just put yourself in this agent's shoes for a second. Imagine dedicating literally half a century to a single company. You've spent your entire adult life building up their reputation, securing their clients, acting as the face of their brand. And then suddenly, you're abruptly told that your time is up. So how much notice do you think you legally deserve? How much time is actually fair to unwind a 50-year career?
Section 1, half a century of loyalty.
Now, we aren't talking about some brief summer internship here or, a standard 5-year contract. This insurance agent, Sohrabji, worked faithfully for Oriental Security Assurance for nearly 50 years. That is half a century of continuous service. Think about that for a second. That represents decades of unwavering loyalty, navigating constantly changing markets, and consistently serving as the face of the company to the public. It's a deeply entrenched, highly dependent professional relationship.
Section 2, the abrupt dismissal, a sudden end.
3.5. Out of nowhere, the insurance company abruptly tells the agent that his agency will be terminated in a mere 3.5 months. Just let that number really sink in for a moment. 3.5 months to pack up 50 years of professional life.
This brilliantly illustrates the absolute crux of the problem. On one side of the scale, you have nearly 50 years of loyal, unwavering service. And on the other, a drastically short termination notice of just 3.5 months. Obviously, this completely shocked the agent. It left him with virtually zero time to adjust his financial plans, transition his career, or even properly wind down this massive book of business he had built for the company over his entire lifetime.
Section 3, the courtroom battle, seeking fairness.
So this became the fundamental question placed right in front of the judge. Is 3.5 months actually a reasonable notice period after a 50-year relationship? Now, in agency law, terminating a relationship isn't inherently illegal. It happens all the time. But the way you do it, that absolutely matters. The judge had to carefully examine the immense length of this deeply entrenched agency relationship against the harsh, really abrupt reality of the sudden dismissal.
Section 4, the final ruling, setting boundaries.
Well, the court delivered an incredibly powerful, unambiguous ruling here. They looked at all the facts and stated unequivocally that providing such short notice after almost 50 years was, in their exact words, illegal and unfair. It wasn't just, poor business etiquette. It crossed a definitive legal line. And this leads us directly into the legal concept of wrongful termination, specifically within an agency context. This occurs when a principal ends a longstanding agency agreement without providing the reasonable notice required by law. Because they failed to give the agent a reasonable amount of time to actually transition out of a half-century career, Oriental Security Assurance committed wrongful termination. The notice period quite simply did not match the tenure. So, what's the big takeaway here? Well, for the law students and professionals tuning in, here is the essential legal formula you absolutely need to remember. Number 1, long service legally demands reasonable notice. The longer the service, the longer the runway required to end it. Number 2, unreasonable notice equals wrongful termination. And number 3, principals fundamentally owe a duty of fairness to their long-standing agents. The law will actually step in when corporate abruptness violates that basic fundamental duty of fairness.
As we wrap up this explainer, I want to leave you with a final thought to really consider. How well do your own professional agreements protect the time and the dedication you invest into them? Because as we saw with Sohrabji, loyalty is a massive asset, but you have to ensure that the law and your contracts are actually there to protect you when that loyalty is suddenly no longer required. Thanks for joining me for this breakdown, and keep asking those important questions about the agreements that shape your own professional life.